Objection number 7, expert witnesses. Qualified experts may give an opinion based on their personal observations, as well as facts made known to them at or before the trial. The facts do not need to be admissible evidence if they are of the type reasonably relied upon by experts in the field. Experts may give opinions on ultimate issues at trial. However, in a criminal case, an expert may not state an opinion as to whether the defendant did or did not have the mental state at issue. To explain what the direct examination of the expert should cover in mock trial, let's first talk about what happens out in the real world. In the real world with an expert, the expert has to be shown to have a background and qualifications and an expertise to make them qualified as an expert to give an opinion that would be admissible at trial as an expert opinion. The attorney offering that expert would formally offer the expert as an expert, and then there could be some argument as to whether the expert is qualified. We don't do that in mock trial. That is, we don't formally offer the person as an expert, because there is always a stipulation that provides that each of the experts is an expert on their area, so that we avoid that time consumption in our mock trial of having an argument about whether they're qualified. In mock trial, we do, however, go on to lay foundation with the expert, ask about their background and their expertise as a way to give credibility to the witness and have more weight with the trier of fact, whether that is a judge or a jury. In our county, in mock trial, we only have a judge as the trier of fact. So you would ask what this person does for a living, what their area of expertise is, and what they found out about and came to an opinion about for this case. In mock trial, the opinions that the expert gives are in the witness's statement. The witness can also be expected to know what the witness would reasonably know from the fact situation, stipulations, and exhibits, just like any other witness. But in cross-examining an expert on the expert's opinions, you really want to stick with the statement that the expert gave. Don't start asking them about all the things they didn't think about, because then you're asking them to talk about and give opinions about something that is not in their record, and then you would walk into the area of unfair extrapolation, which, if you want to watch that video, that's Rule 1 in the mock trial case packet. A couple ways to think about the cross-examination of an expert would be looking through their statement to determine where is this expert giving opinions that are contradictory to each other. The other thing to delve into is to look at your own case theory and see what that opposing expert says that actually supports your side of the case, and elicit that on cross-examination and argue that in closing argument as helpful to your own case theory.